drawn by Judge D.Y. Chandrachud and Judge Ashok Bhushan, through analysis of the judgments in the cases of Jian Kaur and Aruna Shanbhag. In addition, they have made comparisons to the Transplantation of Human Organs and Tissues Rules, 2014, which permit advanced medical directives for organ transplants. Moreover, the court cited the Mental Health Care Act, 2017, which acknowledges advanced instructions for individuals suffering from mental illness. It details the process for documenting and carrying out such a medical directive, including the executor's informed permission, the obligations of the healthcare practitioner, the creation of a medical review committee, the nomination of patient representatives, and the safeguards granted to medical practitioners. More crucially, the judges have drawn inspiration from the Puttaswamy decision, in which the court outlined the connection between the notions of dignity, privacy, and personal liberty to provide the groundwork for this right. In order to highlight the same, they have concentrated on the ideas of sanctity and quality of life that have been infused into modern jurisprudence through a number of decisions by the Honorable Supreme Court, from the case of Maneka Gandhi to K.S. Puttaswamy judgment, analysis of international jurisprudence on euthanasia by the court. To support its decisions, the bench has extensively researched relevant international jurisprudence. Following in the footsteps of the bench in the Shanbhag case, all of the judges analyzed the House of Lords judgment in the Airedale case, in which the House of Lords evaluated both libertarian and utilitarian perspectives in legalizing passive euthanasia for people in a persistent vegetative condition. When giving its judgment on the issue of whether to permit withdrawal of medical treatment or life-supporting equipment for a patient who is in a persistent vegetative condition, the court stated that a special case to the rule of the sanctity of life can be made when individuals are not expected to survive or recover and are in a condition where a majority of medical practitioners believe that extending their lives is not in their best interests. Giving medical assistance to such an individual who doesn't want to pursue treatment and who gets no benefit from such treatment would actually constitute forceful physical intervention of that patient. It is also highlighted that, in order to prevent abuse, the court's view must be sought in certain circumstances, such as when there is a discrepancy among the medical practitioners, a conflict between the opinions of the family members, a difference between the parent or guardian and the professional opinion, or when the relative of the patient is not present to provide consent. It is also noted that life extension in these situations is a no-win and all-lose scenario, and the expertise, efforts, and resources that would be invested in extending the life of an individual could be productively applied to restoring the well-being of other individuals who, if treated properly, may be able to have a productive life. Despite allowing passive euthanasia, the judiciary chose not to create a law on the subject and instead gave the legislature the opportunity to discuss the issue. Additionally, the bench has relied on other rulings involving assisted suicide, such as R.V. Director of Public Prosecutions, 1995, which underlined utilitarian reasoning and the concern for individual autonomy. Additionally, Judge D.Y. Chandrachud and Ashok Bhushan have taken into account the requirements of the Mental Capacity Act, 2005, passed by the British Parliament. It contains specific guidelines about the ability to give his or her consent, the appointment of a caretaker, and the value of medical advice. It is noteworthy to observe that the adoption of this legislation has led to a concentration on enhanced healthcare services rather than the discontinuation of medical treatment, despite the fact that the guidelines proposed by Chief Justice Deepak Misra closely resemble its contents. The United States legal framework regarding the freedom to decline medical care and physician-assisted suicide has also been explored in depth by the court. The court, meanwhile, has chosen to ignore physician-assisted suicide and instead draws inspiration from the right to decline medical care. Not just this, the bench members, Chief Justice Deepak Misra, Judge D.Y. Chandrachud, and Ashok Bhushan, have referred to euthanasia and mental health-related legislation in several nations. Some of these nations or states are Colombia, Montana, Washington, Oregon. These states or nations also have authorized advanced medical directives, along with the guidelines to execute these directives. The court has also cited the case of Cruzan Verst, Director, Missouri Department of Health, 1990, in support of their judgment in Cruzan Free. Director, Missouri Department of Health. the Supreme Court of the